who is a law lecturer, Dr. Almut Gadow, who's a law lecturer and linguist who taught at the Open University. She was dismissed summarily from the OU for questioning their requirement to liberate the curriculum. I'd like to find out what that means. By teaching gender identity. Her solicitors are Doyle Clayton, whose clients have included Maya Forstater, Raquel Rosario Sanchez, James Essers, and LGB Alliance. Quite a few of people we've interviewed actually in the past. And her barrister is Acua Reindorf KC. The hearing has now been slated for a month, from the 24th of February to the 21st of March next year. The Crowd Justice link is going to go into the chat. And if you want to support her, and if you want to hear even more about what's the progress of her crowdfunding is, you can have a look at that. Now, please put your Zoom screen on speaker view for the best view of the discussion. And do please mute yourselves to hear a fascinating talk. Welcome, Almut.
Hello. Yes, thank you very much, Alison.
How are you doing?
I'm good, thank you. Now, whether I can answer the question what liberating the curriculum is, I'm not entirely sure. I'll do my best, but I can't be able to.
Don't expect anybody really knows what it means, if it means anything at all.
I think it is certainly something very sinister, because anything that is a liberation or calls itself a liberation while in fact trying to take away people's rights is something sinister in my view.
Okay.
Liberating the curriculum is essentially is what liberating the curriculum is all about.
Okay.
Yeah, but yeah, I'll come to that in a bit, maybe when I talk about the reasons.
So I would really like to hear you talk a bit about your case. In fact, I could listen to you all evening. I've heard you speak before, and I know what a good speaker you are. Your solicitor, James Murray, he's published quite a bit on this issue. Is that right?
That is right. I mean, as a legal academic, it's perhaps no surprise that I chose the solicitor who had written about the kind of legal points that I want to be made in my case. And he was just a perfect fit for me in the sense that he has written a lot about the human rights side of academic freedom, which is exactly where I'm hoping that my case is going to go now. And it so happened that actually in the course of saying the things that I ultimately got sacked for saying, I often talked about academic freedom and the fact that as a matter of human rights, people at this university still are allowed to say the following, aren't they? So he was just kind of already there. He was somebody who had already developed in his academic writing some of the points that I'm hoping will now be put before a court in my case, namely the fact that as a matter of human rights law, academics have a great degree of freedom of speech that the university cannot just limit because they say it's university policy that rather you didn't talk about certain things, that rather you didn't express certain views and so on.
And this is a special category of freedom, isn't it? I mean, the European Convention grew out of post-war period when freedom to speak had been threatened or done away with in many cases.
Oh, absolutely. I mean, the entire human rights law framework that we have now is really a child of the post-war years. That's when we got the Universal Declaration of Human Rights, which is quite closely mirrored then in the European Convention on Human Rights. So on the one hand, you can say that the human rights law that we now have is a response to the horrors that had just happened in the course of the Second World War and a way of enshrining the never again in law. What I also often emphasized back in the day when I taught human rights law is the fact that, of course, it therefore developed during the Cold War. As people hear European Convention on Human Rights, and they're sometimes kind of associated with the EU, which kind of maps then onto Western Europe, onto what in the Cold War would have been the NATO countries, not the Warsaw Pact countries. But of course, the European Convention on Human Rights was pan-European. It was the Warsaw Pact countries as much as it was the NATO states. It goes to this day all the way to Vladivostok or Antalya. So it never was a Western European and therefore a capitalist thing. So that's one of the reasons actually when I hear people say that freedom of speech is a far-right dog whistle, I always think, well, not really. It's there in Article 10 of the European Convention on Human Rights. And throughout the Cold War, these were the principles on which socialist and capitalist states could agree.
Yes.
So it is not a party political issue. It is not a left or right issue. Freedom of speech is just a fundamental human rights and the basics of democracy that nobody in their right mind should really feel able to dispute, because certainly not even Stalin thought he could.
But he did, in fact, didn't he, in great degree?
There's always a difference between human rights as they are on the books and human rights to the extent to which they are respected and enforced.
Yes.
But if people try to attack the concept of free speech or academic freedom by saying it's a right-wing dog whistle, then I like to remind them that actually throughout the Cold War, the socialist countries felt able to be signed up to a convention that confirmed freedom of expression, the freedom of expression on which I'm now relying in my court case to be a fundamental human right that nobody should be denied.
And I think that the UK was one of the prime movers to get this written. I think one of our jurists had played a great part in writing and drafting the European Convention.
Absolutely, it was essentially written by lawyers from the UK, the European Convention as it now is. Which is interesting when you now hear people saying we should come out of the European Convention on Human Rights because it's these European foreigners imposing things on us, and it doesn't fit with the British way, and we want a British Bill of Human Rights. Now, I happen to strongly disagree with those views generally, but it's just also historically illiterate.
Yes.
And in some ways, you might actually argue that it's particularly important in a country like the United Kingdom, which doesn't have a written constitution. If you go to most of our European neighbours, they will have a written constitution, and the first articles, the first pages of the written constitution will normally be the human rights written into the most basic law of their country. Of course, in the UK, we don't have that, and we see that very specifically in relation to freedom of expression and freedom of speech, because there actually isn't a homegrown right to free speech. And we might come on to this in more detail later on when we talk about the extent to which people rely on freedom of belief to protect their right to things like expressing gender critical views. There are many good reasons why people have relied on belief being a protected characteristic under the Equality Act to defend the right to express gender critical views. But of course, one of them is this strange thing that you can't actually rely on a UK right to free speech. You can rely on a UK right to express a protected belief under the Equality Act. And I think that's part of the reason why people are using the Equality Act to defend our right to say the kinds of things that a liberal voice for women stands for.
Okay, but I'm not a lawyer. I know you are, but so perhaps you can explain or help me understand that our rights to the benefits of the European Convention are inscribed in UK law through the Human Rights Act, right?
Oh, yes, they absolutely are. So
Right.
they've become part of domestic law through the Human Rights Act. Before that, it was only a duty that the UK had in international law to respect the human rights, the ECHR right of its citizens.
And a claimant had to go off to Strasbourg.
Well, they didn't necessarily have to go off to Strasbourg, but it certainly made it more indirect and made it more remote. And of course, it also meant that it wasn't something you could automatically rely on in UK courts.
Okay.
Now, of course, the way that human rights law works is still quite indirect. And I think that's one of the reasons why we're struggling to get academic freedom of expression respected by our HR departments in university, is the fact that often university administrators and the like don't quite understand how human rights law works, because you can't really go to an employment tribunal and bring a claim under human rights law as such. The way it works most of the time when human rights law is used is that all other law in this country, wherever possible, has to be read and interpreted and applied in a way that is consistent with human rights law. So what that means is that when university HR officer use any bit of employment law, or when they use any bit of equality law, or what they like to call the Equalities Act that doesn't exist, which Stonewall has convinced them exists, even if you're applying the Equalities Act or whatever other piece of legislation, you have to apply that in a way that respects human rights, which means that it has to respect the right to freedom of expression that academics have. And the European Court of Human Rights has said time and again that academics have just about the highest freedom of expression that anybody ever gets.
Of course.
So they've said that academics, along with journalists, get the highest level of freedom of expression anybody in society will ever have. And that's for the obvious reason that society at large benefits from journalists and academics in particular being able to share with others what they know. We, the taxpayer, pay an awful lot of money to universities to create and disseminate knowledge. So if the people who are being paid to be the sources of knowledge in a way in this country are then not allowed to share what they know because it somehow goes against some curriculum liberating policy, society at large loses out. That's part of the rationale that the European Court of Human Rights has given in that sense. And they've talked about the fact that in a democratic society which relies on sort of public reasoning to make decisions, because democracy isn't just the whim of the majority. It should be a process of having a debate where we draw on knowledge to arrive at the best possible conclusion. Well, again, that only works if the people with the knowledge are able to provide their knowledge and feed it into the wider debate. And when you talk about things like gender critical lawyers or gender critical criminologists, in the case of my former colleague, Joe Phoenix, of course, we might have debates about prisons or about criminal justice and about the position of trans prisoners and trans identifying offenders in the criminal justice process or in prison. Now, what happens if the people who know most about criminal law or most about the criminal justice system aren't allowed to say certain things about trans offenders or trans prisoners because the university is signed up to the Stonewall Diversity Scheme? Answer: we get less good policy, we get less good public debate. So that's why it's so important for the full extent of academic freedom of expression, as the European Court of Human Rights has already recognized it, to really be respected in our UK universities, in my view.
Yes, and of course, as a liberal, I would say that this goes back to John Stuart Mill and Harriet Taylor Mill's essay on liberty, which is the foundation of creating policy by having this open debate. And this is what you're talking about, bringing it up to date with the European Convention. So it's rooted in liberal philosophy.
Was it Michelle Shipworth who has this lovely anecdote on John Stuart Mill? I think you know Michelle Shipworth was the one who got into trouble because she set a task that involved looking at data about slavery in China. And I think she talks about the fact that at one point she wrote to one of her superiors, and in an email she referred to J.S. Mill, to which her superior replied, "My academic discipline is, I'm not quite sure what, so I don't know who J.S. Mill is."
Oh, that's shocking.
That is the state of academic freedom. That is the state of liberal democracies in our universities today.
And the fact that you can actually download John Stuart Mill, Harriet Taylor Mill's On Liberty free from the internet, it just means that it is there for all of us. Okay, let's go away from John Stuart Mill now and come back to your specific case and your lawyer having written quite a lot about these articles in the convention, then presumably. So you got a lot of confidence in his capacity.
I absolutely do. I mean, it's always a good sign if a lawyer is interested in the issues in your case, not just because you're paying them several £100s an hour for it, but because they are so committed to it. In James Murray's case, that he's actually a part-time academic who spends his time researching freedom of expression and how it interacts with employment law in relation to academia.
And how would that work if his employers, as a part-time lawyer, as a part-time academic, tried to fetter his academic freedom? We would all be the worst, wouldn't we?
We absolutely would. Yes. I believe he's at Buckingham, where there's a slightly different culture in relation to academic freedom. than at a lot of universities. So maybe that is just as well. I think perhaps one of the reasons why he's ultimately found his way to the law firm where he is now is also the fact that he really wanted to work for a law firm that would let him do this, that would allow him to speak publicly on these issues. If you've looked at my crowdfunder, you might notice that actually when we originally put out my crowdfunder, we didn't mention who my solicitor was or what firm my solicitor was at.
Right.
Because not every law firm in this country will go public and say, we are representing somebody who's a gender critical academic, quite frankly. Like you say, he's now found his way to Doyle Clayton, who've almost got a reputation for winning the gender critical cases over and over, and he is now able to speak about these kinds of things publicly. I think in the last 24 or 48 hours, I've seen another quote actually in a national newspaper from him about the employment rights bill, which might be another attack on sort of freedom of speech in any space in which an employee might then get offended by what you say. So it is, he is
a
now.
live issue.
Yes. So he is now, luckily, he is now able to speak about these things more publicly as well, which is great.
Excellent. Okay, but I keep dragging you away from the point. Let's get back to the point, and that is your particular case. Now, obviously, there are going to be aspects that you're not able to share with us for obvious reasons. Well, for reasons that I would think are obvious, but clearly you can't share all of your case and all of the circumstances. But if you can tell us a bit more, then do please.
Yes, I'm not sure that there's that much generally that I can't talk about. I mean, I perhaps wouldn't, single out particular individuals and say who said what at any given time, but in principle, I think the case has been lodged with the court. It's a matter of public record. So in that sense, I'm personally not shy about talking about my case generally. And I'm not even the first person to go public with her case against the Open University, am I? My former employer, the Open University, has almost become a byword, I think, for the loss of academic freedom in our country today. And by that, I don't mean that issues are unique to the Open University, they're not. But the Open University has become a microcosm within which you can see reflected really all the attacks on academic freedom that you've seen in UK academia in recent years. If you name any form of cancel culture in academia, I will show you an instance when it happened at the Open University, really. So to just name a few of the classics. Cancellation of events because activists don't like speakers. Well, if you've read the judgment in Phoenix versus Open University, you know it's happened with a conference that they were organizing, I think, on prison abolition. The angry mobs hounding out a fellow academic because they don't like that academic's idea. Well, those were basically the facts underlying Phoenix versus Open University. Academic research being redirected to produce outputs which supports the ideology that is currently in power. And academic research at the same time being encouraged not to produce any findings that contradict that sort of ideology. Well, my former faculty, the School of Law at the Open University, has a sort of performance metric they report, which is how much of their research output aligns with their social justice mission, as they say it. For which read how much of our research output reaches the conclusions that the EDI department wants us to reach. And if you don't reach the conclusions EDI departments like to see, then you're practically letting the team down.
Gosh.
Yeah, you get teaching in higher education being aligned to sort of promote these EDI ideologies, which again, the Open University has an EDI plan now that says we want to modify all current curriculum and we will make it anti-racist and intersectional and decolonized and various other things. So all curriculum has to become a vehicle now to promote these ideologies.
So if you want to go and study a course at, let's say, the Open University, your course will be littered with things which are not necessarily factual, but inclined towards a particular viewpoint.
Well, littered is your word, not mine. And I think in practice, to some extent, it will depend on the people who run that particular course. But well, you make of that word what you will. They will modify all current curriculum to make it anti-racist and intersectional and whatnot. A curriculum isn't going to be anti-racist and intersectional and decolonized unless it includes elements of those kinds of ideologies. And I have talked publicly about the fact that part of what motivates me here is the fact that my family has seen two totalitarian dictatorships in Germany and has seen two totalitarian dictatorships take over universities.
Yeah.
And so this idea of making any subject in the academic curriculum a vehicle for advancing and conveying the tenets of the ideology that keeps those in power is something that really touches a nerve, I think, with anybody who's grown up with that collective memory. And of course, that is exactly what was going on then in my faculty. And that was really where I got myself into trouble, because the law school then decided that they were going to liberate the law curriculum, meaning they were going to, in some way, shoehorn these ideologies into everything we teach. And there was actually a missive somewhere that, you know, they were going to check every single week of students reading to make sure that these ED ideologies were somewhere in every single week of every course, of every module that a student take along their law degree.
Whether or not it was appropriate.
Appropriate is not a question that anybody has asked in this context, as far as I know. If you look on their materials on liberating the law curriculum, nobody ever asked the question, is it appropriate? Is this something we should or shouldn't be doing? To what extent should we be doing this? Are there areas we shouldn't be going? It is only ever a question of how can we liberate the curriculum? What will liberating the curriculum look like? What more can we do to liberate the curriculum? That is all there is to it. So it just led to quite bizarre teaching materials a lot of the time. So I mean, on one module I taught, not the criminal law module, we basically started having teaching material that talked about the Windrush generation being illegal immigrants. Now that's utter nonsense. The Windrush generation came here on British passports from one part of the British Empire to another at a time when places like Jamaica weren't independent countries. But that didn't really matter. You didn't have to have any knowledge or understanding of the Windrush generation. So long as you talked about the Windrush generation, brown people being victims, and found a way of shoehorning that into the teaching of law, that seemed a good idea.
Wait. The curriculum was saying that the Jamaicans who came here from the West Indies, not just Jamaicans, were illegal immigrants. We asked people to come to the mother country.
Yeah, and I mean, it was just almost an aside, but they obviously decided that within a particular unit, because things have to be anti-racist and decolonial, amongst other things, you had to have something about brown people from the global south, to put it crudely, and in particular about them being victims. How can we fit this in? Well, maybe if we can bring in the Windrush generation here, then we've talked about brown people. And that has decolonized our curriculum and made it anti-racist. It is absolutely absurd. And that was one of the situations where I actually objected. I think I've talked about the fact that I actually spent quite a few years of my life in the global south. So these silly attempts actually to bring in the global south that speak from a place of ignorance, well-meaning ignorance, of course, in the case of you know, talking about the Windrush generation, but still absolute ignorance. They can really wind me up. And I challenged that in relation to the Windrush generation example. And I got the response that you normally get when you challenge stupid teaching materials, with people saying, yeah, fair point, we'll have another look at that. And on another module on which I taught, they basically started saying, sort of assignment after assignment was asking, how could English law be used to improve the lot of people in the global south, or as they kept putting it, in many developing countries. The question always assuming that the law in developing countries is inferior to English law. So if the law in developing countries was as good as English law, how wonderful would things be there? Again, this is ignorant, stupidly ignorant, but well-meaning, because what's happening is that people feel the need now to talk about the law of countries in the global south. No, these people are only trained in English law. So they don't know anything about the law of any country of the global south. But to liberate and decolonize the curriculum, you have to talk about the law of the global south. So you get these kind of extremely absurd outcomes. English lawyers telling people, can you use English law to talk about countries in the global south being victims? So that was another situation where I really challenged the curriculum liberation. And again, the response I got at that time was, yeah, thanks, we'll have another look at that, fair point.
And did they change it thereafter?
I believe, yeah, the assignments that were set the following year weren't quite as extreme in that regard. Because,
Right.
I mean, usually when you point it out, at least people do realize what they've said there isn't actually all that clever. And well, we then got similar absurdities on the criminal law module that I was teaching, specifically in relation to gender. And I think there might have actually been some connection to Joe Phoenix, quite frankly, because this was the academic year in which the chair in criminology, Professor Joe Phoenix, publicly resigned and went public saying that she was suing the Open University for the way that she had been hounded for being a gender critical criminologist and for setting up the Gender Critical Research Network. So I think that might have been part of the motivation why the criminal law module in particular had to had to really double down on the gender ideology. But whatever the motivations, they then decided that we had to teach students gender ideology in our criminal law tutorials. So I was told that I had to use offenders' preferred pronouns like they, them pronouns in a criminal law tutorial. And I started questioning that. And that is ultimately what I got sacked for. So, you know, I did things like asking my managers to explain the rationale behind it. I asked them to define the core concepts. I asked them to refer me to literature. I pointed out what that would logically mean if you let defenders in the criminal justice process tell us whether they want to be treated as a man or a woman. I referred to some current cases that were currently going through the justice system or through the penal system where male offenders had identified as women. So it was doing all these things to just point out and challenge the instruction that I, in my criminal law tutorials, had to teach my students to use offenders' preferred pronouns. But the reaction when you talk about gender was really different from the reaction that I got anywhere else, challenging the curriculum liberation and anything else. The response I got was, we will not change our teaching materials. This is what you will teach to your students. If you ask again, we will just delete anything you ask. That went on for a while with me sort of bringing it up periodically, saying that this is still an issue to which I need an answer. If you're dictating what pronouns my students have to use in my tutorial, I want an answer to this.
So even though there isn't a requirement in criminal law that you have to use the preferred pronouns, let's say, of a defendant, it isn't actually a legal requirement, is it?
There's no legal right to be referred to by your preferred pronouns at all, no.
And if you're alleged to have committed, let's say, a sexual offence, there actually is an exception in the Gender Recognition Act, isn't there? That you can be accused of an offence that could only be committed, let's say, by a man.
Yes, I think the law as such doesn't deal with whether in the criminal process you should be treated as a man or a woman. There have been various forms of guidance, both from the professional bodies for lawyers and also from what's called the Equal Treatment Bench handbooks, which is sort of equality guidance for judges as to what pronouns should be used for offenders. But these are actually issues that I brought up at the time, that, for instance, one of the core principles of evidence in our court has always been that evidence should be given in the witness's own words. So, you know, if the witness says he must have been in his 20s and actually he was 40, the witness will still say, the witness evidence still is it was a man in his 20s. Or, I don't know, if the witness says he looked Asian and in actual fact he's South American, the witness evidence will still be it was an Asian man. And by the same token, if the witness says, I saw a man raped me with his penis, nobody should tell the witness, no, you need to change your evidence. You need to say a woman raped me with her penis, because our rule has always been that a witness's evidence should be in the witness's own words.
Right.
And the other point I made in that context, well, I made quite a few points in that context, is that criminal lawyering is about presenting facts. And when I talk about offences that are committed by one human body against another, which is basically violent offences and sexual offences, then the sex of offender and or perpetrator matter. The gender identity of the offender does not matter. So if I'm talking about a case that involved one person attacking another, it matters. It is a relevant fact whether he attacked her or he attacked him or she attacked her. The jury will judge a situation of him attacking her differently to her attacking him for good reasons, because all other things being equal, we can assume him to be physically stronger than her. So if we want to teach our students that a lawyer's job is to present the relevant facts, a prosecutor's job in particular is to present the relevant facts, they need to learn to highlight the relevant facts, because
And do it clearly.
Yes, highlighting facts is their job as a criminal lawyer. Affirming an offender's identity is actually not a prosecutor's job.
Yeah, good point. I thoroughly agree with you. It seems obvious, and it seems to me that if you're teaching students that they have to affirm gender, which is not necessarily factual, is it? Over sex, then you're going down a completely different route from however our laws have been decided in the past.
You are, and you're also teaching students what is effectively a contested belief, which is another thing that I actually talked about when I challenged this and questioned it. It questioned the wisdom of this instruction. It is, as I said at the time, a hotly contested issue whether this offender should then be referred to as he or they or she, when in fact the offender is a male. And there are different perspectives on it. So if you want to bring it up at all, in any kind of teaching, whether you're teaching law or any other subject, then you have to introduce your students to the full range of views on it. So you can explain to your students the reasons why some people think the right thing to do is to use an offender's preferred pronouns, and also explain the reasons why other people think it is not the right thing to do to use an offender's preferred pronouns in all circumstances. I use the analogy of the time of the time because this is a protected belief, remember, a belief in God. So it is perfectly possible to say we will teach law without ever discussing the question whether there is a God or not. But if you're going to start talking about God, you have to reflect that some people believe there is a God and other people don't believe there is a God. And the same applies to gender identity as another protected belief. Some people have the protected belief of believing there is gender identity, which determines whether somebody really is a man or a woman. Other people don't believe it. There is such a thing as gender identity, and being a man or a woman is just a matter of biological facts. So on a contested issue, any adequate academic teaching will either introduce the student to the full range of perspectives or to none. You cannot pick one side in a hotly contested current debate and then abuse the classroom to teach your students that that is the one and only right way to think in this ongoing debate.
Yes, I see. I've just had a question wanting me to ask you. What response did you get from the students?
I didn't involve the students in this. This was entirely a debate I had with my fellow academics. It wouldn't really have been fair, amongst other things, to involve my students in it. It also wouldn't have been appropriate, really, because this was a first-year undergraduate module. This, it is basically students in their first year at university still finding their feet. It wouldn't have been right to involve them in this at all. This was the things that I got sacked for were things that I said on a forum for criminal law tutors.
I see. Right. So that was a closed forum of staff rather than something happening between yourselves and the students.
Yes, absolutely. So I didn't go into my classroom and say, well, my managers have told me that we should use they, them pronouns, but of course, that's all ideology. I didn't do anything of that kind.
Yes.
I went back to the people who had asked me to use preferred pronouns in my tutorial and said, I don't agree. You need to explain why. You need to give me your sources. And I only ever raise this within the context of an academic debate, by which I mean talking to my fellow academics, talking to fellow criminal law academics about the teaching of criminal law.
And so in this conversation that you were having, were you the only person saying no?
No, I wasn't quite the only person. I was the most vocal one, and probably if I hadn't brought it up, nobody else would. I mean, there were a couple of people who expressed that they agreed with me. There were a couple of people who expressed that they did agree with me, and there were a few people who didn't speak out, expressing a view one way or another. I mean, I remember one of the people who disagreed with me said things like, "Oh, that's another really illuminating point, Almut. I look forward to the Ministry of Truth coming along and deleting what you've just written." So that was one of my favorite posts, yes. Of course, shortly after the Ministry of Truth came along and deleted what I'd written and what she'd replied to what I'd said. But interestingly now, even the fellow academics, the fellow criminal law tutors, I mean, who disagreed with me, did it in a perfectly grown-up form of saying, "Almut, I don't agree with what you're saying on gender, and these are my reasons for disagreeing with you," which is a perfectly acceptable thing to do when several academics are talking to each other about their subject area. And I emphasize I was posting on a criminal law forum, on a criminal law tutor forum. So it was actually a space for people who teach criminal law to talk to each other about the teaching of criminal law. None of my fellow criminal law tutors ever expressed being offended by any of what I said. The people who chose to take offense about what I said were all law school managers. In fact, the person who then penned the management complaint on the basis of which I was ultimately dismissed came from she was quite high up in the university. She was the Associate Dean for Student Experience, but she came from the business side of the Faculty of Business and Law, and she didn't even have access to the forum on which I was posting these things because she wasn't a criminal law tutor. So she penned a complaint about the offence I was causing by talking to criminal law tutors on a forum to which she didn't have access.
Crikey.
Yes.
And were you able to take any screenshots of the forum before
I've got the forum threads for which I was dismissed, yes, and I'm sure in due course they will all come out. But I mean, if you looked at those threads, this really is academic debate. This is not me being abusive or to use the word that keeps being thrown about, transphobic or anything of that kind. I mean, another interesting point actually about the people who complained about me. The complaint is that I was somehow offending people who were trans or know somebody who is. Do you know how many trans people or trans-related people complained about me? None, not a single one. It was the managers who had decided to liberate the curriculum by making me teach trans ideology who complained about me. No trans people complained about me talking about what I'd said on the teaching of trans ideology. And no law tutor complained about what I'd said on a law tutor forum. It was the managers, the curriculum liberators who complained about me. And it was the complaints of those curriculum liberators in management position that led to me being dismissed.
I think that's really, really important point, isn't it? So no complaints from your students and no complaints from the people who were doing as lawyers will do, exchanging points of view, because that's how you get a better understanding, right?
As all academics will do, exchanging point of view, of course, because that is the model we have in academia. Basically, you put your ideas out there to be challenged by somebody else, and as the ideas rub against each other, we hone them and improve them, probably through cross-fertilization and through having to defend our ideas, and in that process, hopefully drop the bits that aren't convincing, taking on board things that are more convincing in relation to what other people say. Now, you say they're all lawyers, which is of course correct, and the thing about lawyers is that their whole existence is about winning arguments. So perhaps lawyers can get that little more argumentative or more forceful in expressing a point, probably, than, say, HR officers might be when talking to each other, or even people from management studies might be, because that's just our style. You know, we were brought up to win arguments by defeating the argument of the learned friend who's standing next to us. That's
Yeah.
what lawyering is all about.
Of course. But
Interestingly, yes, you managed. No student complained about me. No, absolutely, categorically, no student complained about me. What's more, actually, my line manager then told the disciplinary investigation, well, we've looked at Almut's students facing work to see if there was anything we could use against her, but we couldn't find anything.
Ah, excellent. So no offence disclosed.
No, I mean, they went fishing basically for
yes.
students and still couldn't find any.
But your assistant dean that you said had made the complaint about you, how did she know if she didn't have access to the discussion forum? How did she know what was going on?
Well, she hasn't said in terms. I expect somebody with access to the forum will have passed it on to her. I noticed over those months that a certain HR officer kept popping up among the readers of that forum. So I'm assuming that that HR officer was the one who had actually been compiling this complaint over a number of months. And then I actually suspect that much of the complaint that the associate dean signed was written by a HR officer, but I don't know. They have never said where the complaint comes from. It just starts with, so this debate went on all academic year. We get to the end of the academic year. I finish my teaching for the year. I finish my marking for the year. And then I am sent a complaint that is called a management complaint, made up process, signed by the associate dean, where she says, for months, Almut has been saying these things on this forum.
But in a properly and defensibly academic free expression in the format that we've talked about already.
Absolutely. I mean, that is going to be a big part of my case. If there is one place for academic debate, surely it is a space internal to the university where only academics talk and they only talk about their subject area. You cannot get more purely academic debate.
Yes.
And we've talked about the fact that the European Court of Human Rights has said that academics doing their work have the highest level of freedom of expression anybody ever gets. It doesn't matter if the HR officer thinks that isn't compatible with the trans policy that says you have to accept people's gender identity, no questions asked. It's academic debate. You're allowed to debate. That's what human rights law says.
So I'm thinking that when these people are cross-examined, it's going to be absolutely fantastic to hear how they defend trying to close down this debate, isn't it? Because what grounds have they got for contravening the European Convention on Human Rights, this highest order of freedom of expression?
Well, time will tell how they try to defend themselves. Anybody who has followed the case of Phoenix versus Open University might actually recall that actually the adjective I think you just used, entertaining, is almost quite appropriate for the way these cross-examinations went down. I mean, we got some really very interesting things, didn't we, when the academics were being cross-examined in Phoenix versus Open University.
Perhaps you can tell our audience, because not everybody will have been closely following the Phoenix case.
Oh God, I think my favorite witness in the Phoenix case was probably actually the EDI dean. I think at some point she was asked whether a particular series of acts constituted direct discrimination, to which she replied, how are you defining direct discrimination? The most central concept literally of the Equality Act.
Yeah.
The Dean for Equality, Diversity and Inclusion doesn't know what it means and thinks it's a term that the cross-examining lawyer has just made up. So she says, how are you defining direct discrimination? She then has it defined for her and she replies, I'm not comfortable with you using the word discrimination. You're the Dean for Equality, Diversity and Inclusion. You have chosen to be a witness in a discrimination case, and it makes you uncomfortable to be asked about equality and discrimination. So I think she was probably my single favorite one. I mean, they had the and this is not the head of HR, the most senior HR person, whatever her job title is, a director of people services or something. She was asked a few times about university policies, and invariably her response seemed to be, "Oh, I haven't written the policy." When the policy actually said it was, sorry, I haven't read the policy. When the policy actually said it was written by her, but her response kept being sort of, "Oh, I don't know the policy. Oh, I haven't read Joe Phoenix's complaint myself, and I also haven't read the policy under which it should have been handled." So that was another one. But I mean, the judgment in Phoenix versus Open University just really goes into town on the credibility or otherwise of the witnesses. I think the tribunal makes comments along the lines of, you know, we were bearing in mind that these are academics, so they are trained in analyzing and presenting evidence. And they just didn't live up to that standard. And that was one of many places where the tribunal was just struggling to find a polite way of saying they were lying through their teeth.
Not only that, but they didn't know what they were talking about.
Oh yeah, absolutely. That as well. Well, yeah. Yeah, especially the sort of university administration side, they really showed they didn't know what they were talking about. When you then came to the academics who had hounded Joe Phoenix out, they were really being very economical with the truth. They all seemed to be suffering from an awful lot of memory loss when it came to, in particular, who had done what, or they all asserted having very noble motives for what they've done, which then didn't stand up into scrutiny. It really was entertaining in Phoenix versus Open University, and I think it might be again in Gadow versus Gadow versus Open University for much the same reason, and all the more so because they are lawyers who've broken the law after having had the law explained to them. And yeah, Joe Phoenix was in the Faculty of Arts and Social Sciences, and social sciences might be forgiven for not quite understanding the law. Now, the people who complained about me were generally lawyers, and these were lawyers, the curriculum liberators, to whom I'd been saying time and again, as a matter of equality law, gender critical beliefs are protected beliefs, so we have the same right to express them as gender affirmative beliefs can be expressed. And I was saying, as a matter of human rights law, academic freedom commands that people are allowed to say these things that you're currently stopping me from saying it. So even if you hadn't thought about that, even if you if equality law or human rights law isn't your area of expertise, and it is, once these things are spelled out to you, once it's spelled out to you that you're breaking some of the most fundamental laws of this country's constitution, you'd think that as a lawyer, you stop and think, or maybe check with somebody before just continuing ahead after somebody's pointed out that you're breaking the law. But yeah,
now, Jodie's got a question here, and I just absolutely agree with her question. She says, "I'm amazed that the Open University are fighting this. They should settle before they make fools of themselves again." Thanks, Jodie, for that.
Yeah, you might think that. I think it's almost a question partly of who's making the decision here and in whose interests are they making the decision. Is it in the Open University's interests to defend yet another case of this nature? I would say no, categorically not. But of course, it isn't the Open University that's deciding what's best for itself. You have individual leaders making a decision. And a good leader of a university will ask themselves, what is the best thing for the university? A bad leader will ask, what is the best for myself? And I'm happy to drag down the university in doing the selfish thing. Now, of course, these leaders are individuals who, well, if you've read the Phoenix judgment, that talks a lot about fear being what motivated university leaders. It talks about the fact that they allowed the campaign of harassment against Joe Phoenix, not because they thought they were doing the right thing, but because they feared the genderist community, the trans activist community. They weren't willing to stand up to the trans activist community. And I think that same fear is still there on a general level. So on a general level, they would have to face the wrath of those trans activists if they now settled Gadow versus Open University. So that's one area where they would make enemies. The other area will be the curriculum liberators who've been complaining about me, of course, because these people are people a lot more actually in the law school than in Joe Phoenix's case, were acting on the basis of missives that had been coming from university management for a very long time, encouraging people to be trans allies. And of course, practices of allyship that people get taught in training programs on how to be an ally look very, very similar to the harassment and bullying that the tribunal observed in Phoenix versus Open University. So if these people who've hired on a gender critical academic because they've been told that's what the university wants you to do, because that's EDI in practice, that's trans allyship. If you take that into your appraisal, you're more likely to get a promotion. If the university now says these people who did what we asked them to do did the wrong thing, then those university leaders have made yet more enemies. So I do think it is a case, above all, of them not having the backbone to A, say we got this wrong, we got this case wrong, we're not going to pursue it because what we did was just wrong, and B, say to their managers, say to the middle managers, what's been going on, what you've been doing, what we've been encouraging you to do was wrong as well. I think that is the reason. I think that is what motivates the university to keep pressing ahead with this.
I think what you've just analysed there seems to me to be common with all the cases we've been looking at. Now, I think we've referred people in the chat to the cases of a number of cases that have been analysed in Reading University, and that's in the beginning of the chat. Perhaps we can repost that further down because some people haven't seen that, they've come in since. But there's a really interesting paper that, in fact, Joe Phoenix and another academic produced at Reading, talking about the unprecedented success that claimants like you, let's hope, have been having. Over 80% of the cases, or round about that case, that number proportion, have been won by claimants because of the nature of the misunderstanding and misapplication of the Equality Act. Is that right?
I think that's about right. Yeah, I have to confess, I still haven't got round to reading Joe Phoenix's paper, but yes, I think it is roundabout in that area, and that really is astonishing. We haven't traditionally had that many belief discrimination claims anyway, and out of the belief discrimination claims that go before the tribunal, not that many were won in a final hearing, whereas overwhelmingly, yeah, the gender critical belief discrimination cases keep being won over and over. There might be many reasons for it, but I think one of the reasons is the fact that, of course, this isn't a discrimination that has just come out of nowhere or even grown up organically in the way that you might say, I don't know, in the 70s this country was a bit racist, so you got a fair bit of race discrimination in workplaces, or back in the 70s this country was a bit sexist, so you got sex discrimination in the workplace. No, this is a form of discrimination that has been bred by university HR departments and EDI departments, of course, because I don't think that many people actually felt particularly strongly about trans rights or the like until HR departments and EDI departments started shoving it down our throats at every opportunity. If you've read the round-off review of Joe Phoenix and Rosa Friedman's cancellation at Essex University, you may remember that phrase, Aqua Round-off, talking about Essex University having followed the law as Stonewall would prefer it to be and not the law as it is. And I think there's a lot of that going on that. Universities for a long time mistakenly thought that in harassing gender critical feminists, they are respecting the law and discriminating against gender critical feminists. They are following the Equalities Act. And B, they've been proactively encouraging their staff to do that, because Stonewall likes you to just use every channel on the university airwaves to instill trans beliefs in your staff and encourage your staff to act on those beliefs. So this is a discrimination that has been actively fostered for years. And the HR officers, as the ones who've been promoting these discriminatory ideologies, are really reluctant to row back on that now, and are really reluctant to even admit when it's clear that what they've been doing is discrimination, and the cases that they've got ongoing are cases where the university has discriminated.
And this seems to me to be a really, really worrying development, doesn't it? Because I thought when I was at work that the human resources staff were there to make sure that we were compliant with the law, and that included the European Convention and latterly the Human Rights Act in 1998. So if what they're doing, let's say at Stonewall's bidding, you might not be able to say that, but nothing will stop me. If they're doing that at Stonewall's bidding, encouraging people to forget about the law, forget about what actually is protected and what actually is written in the actual Equality Act, then they're storing up huge problems for their employment situation.
There has been a complete reversal and redefinition of the role of HR officers when it comes to things like equality, hasn't it? And full disclosure, I've actually been many moons ago, I was an equality officer, not for not very long, but I was an equality officer at a local authority. Now, that was back in the day of equality and diversity. This was before we moved on to equality, diversity and inclusion, or equity, diversity and inclusion, EDI. And people sometimes think, even HR officers sometimes think of themselves that this was only a bit of an expansion. We were already equality and diversity. Now that this has expanded to equality, diversity and inclusion. So it's kind of even a bit more of what we were already doing. Of course, the exact opposite has actually happened, because the inclusion is actually the Trojan horse through which they've brought in a set of quite extreme ideologies, genderism or queer theory being one of them, and anti-racism and decoloniality that I've talked about earlier being other examples of those ideologies. And it so happens that those ideologies are all ideologies which effectively call for discrimination. Well, they are. I mean, anti-racism is an ideology that judges people by their race first and foremost, and openly calls for race discrimination. And essentially all these identitarian ideologies do, because they're all about victimhood. And then the thrust of that victimhood is that, or the thrust of that victimhood ideology is that people in the victim category should be in some way privileged among the people who are not in the victimhood category. So trans people are the victims, cis people are the oppressors. Ergo, to create equity, you need to suppress, at the very least, the views of cis women in the interest of the oppressed trans women. And you get that across all the different victimhood categories that you get in your scheme of intersectionality. But the whole idea of intersectionality is of course, that we have lots of identities, and all these identities are along a spectrum of oppressor to oppressed. And the I in EDI then stands for oppressing the oppressor, oppressing the cis person, oppressing the white person, oppressing the man, and so on. So it is actually quite literally the opposite of equality. And we have people in the name of equality, diversity and inclusion reaching the Equality Act, as exemplified, I mentioned earlier, by the Open University's Dean for Equality and Diversity and Inclusion, sitting in a tribunal and saying, I don't know what discrimination is. And then in her next answer saying, I'm not comfortable with you talking about discrimination. That is absolutely absurd. 10 years ago, that would have seemed absolutely absurd, that somebody who is very highly paid to be in charge of equality is in her job role, and she's the most highly paid equality person in the university, somebody who is paid to be in charge of equality doesn't mean what discrimination is and doesn't feel comfortable with discrimination being talked about. But with these ideologies that fit under the I of EDI, that is the new normal. That is what EDI now is.
And yet, now again, I'm not a lawyer, so I'm hoping you're going to be able to explain this to me and to the rest of our listeners. But I've been told that the point of including all these different protected characteristics, 9 protected characteristics, are included in the Equality Act, is that in some cases there are going to be conflicts of claims of rights, and they need to be balanced and they need to be worked through, you know, in a way that brings out the best solution, bearing in mind all the different conflicts.
Of course, I mean, almost always when there's a legal dispute or a dispute of rights, we're talking about balancing conflicting rights, where two different groups of people or two different individuals to some extent have a legitimate claim, such as somebody who's got the protective characteristic of gender reassignment having certain rights, and on the other hand, somebody who's got the protected characteristic of being a woman by sex having rights, or somebody who's got the protected characteristics of having gender critical belief having rights, and they have to be balanced against each other. So that's not new at all. There is no one superior protected characteristic under the Equality Act, contrary to what Stonewall would have you believe. Stonewall would of course tell you that gender reassignment, or the way they've infinitely broadened it to trans or the LGBTQ umbrella in general, somehow trumps all the other characteristics, which is absolute nonsense.
And that doesn't have any basis in our law or practice, does it?
It doesn't have any basis in our law. Now, I actually think in some ways the best thing that the Forstater case has done is that it's taken the language of equality law back of the trans activists. Of course, it's given us the rule in Forstater that gender critical beliefs are protected beliefs under the Equality Act, and you can't be discriminated against for having them, and you can't be harassed for having them. But for these kind of university politics situations, it has just taken the language of the Equality Act back of the trans activists, back of the Stonewalls who were abusing it and misrepresenting equality law. I come back to the fact Essex University, like a lot of universities, thought they were following the law when they were in fact following the law as Stonewall would prefer it to be, not the law as it is. And I think that really started crumbling with the Forstater case, because what we'd been hearing for years from Stonewall and the like was that even if you talk about a case like mine, on the one hand, you have the vulnerable oppressed people like trans people, and on the other hand, you just have freedom of speech run riot. You know, the fascists wanting to be able to harm people without any kind of restrictions with their literal violence. And which side do you want to be on? Do you want to be on the side of the vulnerable and the oppressed, or do you want to be on the side of the fascist adjacents demanding free speech? And of course, that is what Forstater has taken off them, because since Forstater, we can legitimately say that at the very best, you have a conflict here between two protected characteristics. On the one hand, you have trans people who've got the protected characteristic of gender reassignment. On the other hand, you have gender critical feminists who have the protected characteristic of gender critical beliefs. And it is now the job of the university to balance those conflicting rights. So these are two protected groups under the Equality Act. It isn't one protected group on the one hand and the nasties on the other.
Well, I'm really looking forward to your case, I have to say, and I hope you have a great opportunity to say this, and at least if you don't, your barrister and your advocates will be able to do that for you. But it strikes me that this is not the end of this. Even if you win it, whether you win it or lose it, and I devoutly hope that you win it, if they haven't learned from Phoenix, will they learn from your case?
Maybe it takes a few cases to drive the message home.
And there have been quite a few, as we've seen in this Reading document.
Will they have a change of heart because their conscience tells them that actually I've been doing the wrong thing all along and I now need to start doing the right thing? No, I don't think that is going to happen. I've been watching Open University managers for over a decade, and I do not believe that that is what's going to be happening among the top leadership of the Open University. I come back to the fact that fear was the motivating factor in Phoenix, according to what the tribunal found. And I think there is a strong element in that, not just at the Open University, not even just in academia, but very broadly, that the trans activists have been incredibly vocal and incredibly aggressive. So if you want to kind of balance the volume almost between the two sides in a situation where the trans activists are almost always screaming at the absolute top of their voice and causing a racket, whereas the other side is being polite and reasonable, I think that was part of the reason why for a lot of years trans activists kept winning, because the cost of ever saying no to the trans activists was very high. The cost of saying no to the other side of the debate was virtually zero. So upping the ante on the other side, I think, does have its benefits. And in particular, I think it is at the point where it might become disadvantageous to the individual manager to have to go into their next appraisal and say, oh yeah, and also I've been found to have discriminated against somebody, but let's not look at that.
Do you think they'll get away with that?
Well, I mean, for instance, you have to bear in mind that some of those senior leaders who've been mentioned in Phoenix versus Open University might at some point be applying for other jobs at other universities. How well is it going to go down if you are the university secretary saying you're in charge of university policy, and well, you've run the university that got Phoenix wrong and then got a number of other cases wrong as well? Or, you know, if you were the most senior person in HR or various other people, if you were in charge of the Open University's EDI policies, and if you were in charge of the bit of the Open University that should have made sure that this discrimination doesn't happen, but it happened over and over again, I don't think these people are then necessarily motivated by doing the right thing by the university. They will be worried about going on record time and again as the one who are responsible for the Open University losing another major court case.
If they're going from faculty to different faculty, will it be the same person, or will they? I mean, will it be the HR people in total that get criticised, or will it be departmental HR?
I mean, who exactly gets criticised? I don't know. The leaders are often very good at the blame game and at making sure that the blame doesn't land with them. But I mean, similarly, you will probably eventually have managers turning around to HR and saying, you told me that this was the right thing to do. You told me that I should crack down on this academic expressing gender critical views. And now a tribunal has just called me a harasser and a discriminator and a nasty piece of work for doing exactly what you advised me to do. And there it is in black and white, and it's making me look really bad when all I've done is follow your advice, HR officer. So even the HR officers might become really quite unpopular within their institution and might not want to be the ones who get blamed when other people's careers are affected. I do think that the public naming and shaming more than anything is actually the bit that university leadership are going to fear if they keep doing what they're doing.
Yes, I think hopefully that will be the case, and again, hopefully your case will be victorious, because to me, of course, it strikes me as absolutely obvious that if you have this highest order of freedom of expression and they're trying to curb it, they've got to be in the wrong. What defense do they have?
They've got to be in the wrong. What is a university for if it is not a place where people can express ideas and exchange ideas? This bizarre thing whereby EDI departments have essentially redefined the purpose of a university. When I joined the Open University in January 2013, it was still just about a university in the traditional sense, and as was UK academia at large, which is to say, institutions which are there to create and disseminate knowledge. Since then, the EDI departments have kind of come along and redefined the purpose of the university as institutions which are there to advance these ideologies in the process of creating and disseminating knowledge. You cannot pervert the nature and purpose of university in that sense, and universities need to get back to doing what they were originally created for, because otherwise they just become places of indoctrination, places of spreading party dogma. Well, you can frankly achieve that through cheaper forms of propaganda.
Yeah, I've got a question that's going to come up later, but right now I'm going to ask Judith. Would you care to ask your question, because I think it's a real corker. Judith.
Yeah, hi.
Thank you.
It's just when I read Almut's account of her case, one of the things that really struck me was that one of the beliefs they were supposed to be promoting, or at least condoning, appeared to be a sort of positive attitude towards pedophilia. I just wondered what that consisted of. Pedophilia. I just wondered what it consisted of and how it was justified when, as I expect it was challenged.
Well, it is something on which they've been very reluctant to ultimately nail the colours to the mast. I mean, if you've followed this whole area of queer theory, you may be aware that there is a substantial body of literature that talks about the minor attracted, what you and I might call paedophiles, being just another category of a different form of sexual attraction, another particularly oppressed category of the queer, and so forth. The Open University Library, for instance, has a very large body of literature of that nature. Now, my faculty was very clear that it wanted to be inclusive of all sexual and gender identities, but they weren't willing or able to define what all sexual or gender identities are. And they weren't able to say if anything is included or excluded from it. In particular, they weren't willing to exclude anything from that. They then just happened to give students a task that involved a sexual relationship between an adult and a minor. When they had said previously, it's important that we reflect sexual diversity by having diverse kind of sexual relations. So I again asked, can I have clarification? Why is there this relationship between an adult and a minor? And is this part of the agenda of including all sexual orientations? And is being attracted to a child when you're an adult part of the sexual diversity that we want to promote? And they weren't willing or able to answer that question. They still, to this day, aren't willing or able to answer that question. That is in a sort of wider context where, to put it politely, the Open University generally, and my former faculty in particular, has had its issues with their handling of sexual offenders that are members of the university, and where really quite unwise comments have been made to the effect that we want to be inclusive and therefore we cannot exclude anybody who's a sex offender from in situations where excluding them would be a matter of safeguarding, really. So I just had a very uneasy feeling that a longer standing practice of being de facto inclusive of sex offenders was now meeting with an ideology that sort of sugar-coated being inclusive of sex offenders, and that was finding expression in the material with which I was supposed to teach my students. I asked for clarification. I never got an answer. The fact that I asked the question has been cited among the reasons for my dismissal.
Oh, the fact that you asked for clarification is a grounds for dismissing you?
Yeah, the fact that I asked them to define that, yes. That was again, people felt bullied and harassed by the fact that I asked them to define what they meant by saying that we want to reflect all gender and sexual identities.
Wait,
So
wait, law relies upon definition of terms.
Oh, absolutely, yes.
And they were unable or unwilling to come to terms with that.
They were unable or unwilling to answer that questions. They had said, we want to reflect all sexual and gender identities in our teaching. When I said, can you define what you mean by that? They weren't willing to give us an answer to that. Now, you have to, of course, see that in a context where, as I said earlier, people who create the teaching materials are told you have to reflect sexual and gender diversity, and they're not giving a definition, and they're probably also not expert in it. That's part of liberating the curriculum. Now, what do these people do if they're told to reflect sexual diversity in their teaching material and to reflect the full spectrum of sexual diversity? Well, they'll go to one of two places. Either they'll Google it, and when they Google it and Google what does sexual diversity mean, they will get to websites that tell them that being minor attracted is included. Or they'll go to the university library, and in the university library, they will find material that tells them that the minor attracted are included in sexual diversity. So, and I would add that, amongst other things, the law school hired undergraduate interns to do audits of the module materials against their curriculum liberation checklist to make sure all the boxes were ticked, including things like gender diversity, sexual diversity. So when you're telling people to crowbar sexual diversity into teaching materials, but you're not willing to define it, that is perhaps the inevitable outcome, that we have teaching materials that normalize sexual relationships between adults and minors, relationships which by law are criminal offences.
Yeah, it strikes me that there's a safeguarding issue here, but of course, in the case that Raquel Rosario Sanchez brought against Bristol, the court decided that the university did not have a duty of care to the students. So how does that square with safeguarding?
That's a really interesting question. Generally, the idea of the university not having a duty of care towards the students, I think in principle it does have a duty of care towards its students. But of course, it's doubly important at the Open University, because the Open University is the only university in the country that has children as young as 12 enrolled among its students. And it has got adults all the way along the spectrum, well into, you can be 100 and still study at the Open University. And now you combine the fact that we've got children as young as 12 studying at the Open University with the fact that we're also the only university in the country that proactively recruits students in prisons.
Yeah.
So you are in Open University study spaces mixing children with offenders. I've seen material that gets sent into prison by the Open University that's designed specifically to be sent to offenders in prison, which talks about the fact that children as young as 12 teach at the Open University. I cannot think of a better way of advertising yourself as a way of accessing children to paedophiles than sending documents into prison, which point out that children as young as 12 are available and accessible to you if you sign up with us.
Just on a question of clarification, how is it that 12-year-olds are able to study with the OU?
It's the Open University. Open means, amongst other things, that you need no qualifications to get in. There are no entry requirements to get in. I think once upon a time when the Open University started out, it was kind of people who came back to education as sort of mature students almost. So even if they didn't have qualifications, they'd been through the University of Life, and you had to be at least 21 when the Open University was first set up. That was then dropped. So children with no qualifications can sign up the Open University, and this will often be presented as, on the one hand, it will be these child prodigies who get the opportunity to go to university, and it will be children who get the opportunity to stretch themselves a bit and all the rest of it, which happens, no doubt. You do get these kinds of children studying at the Open University. In my experience, most of the under 16s that you get studying at the Open University are actually children who've signed up to higher education instead of secondary education, because they've had very difficult backgrounds, very difficult lives, which resulted in them effectively not going to school, them not being in secondary education, and somebody sells them signing up to an Open University degree as the better alternative in some way. So I actually believe that among the children which are then allowed to mix in this very inclusive environment, to put it politely, at the Open University, there are disproportionately many very vulnerable children as well.
Well, that's a new one on me. I hadn't realised that it was as open as being open to children who should actually be in the regular secondary school system. Okay.
Yeah, I mean, I don't know the exact details of the individual cases, how it came to pass that that this particular child wasn't in school, but you certainly get under 16s among your students who tell you, I'm not at school.
Okay.
I then tend not to inquire how that came about, but it's clear that these children aren't in secondary school, but they have signed up with the Open University.
Right. So if there's materials, actually, I'm going to ask Jane to answer this question because it's your question, Jane. Are you with me still? Would you like to ask this question of Almut?
Yeah, I'm here.
Yeah.
If there are, you said about the university library and minor attracted people, are they academic papers or does it include other source books? So how does that fit in with criminal law and holding certain materials that might be considered for, child abuse material?
Well, the material in the library that I was talking about is generally material from the world of queer studies, which I have to confess isn't really my area of expertise, but I think queer studies then divides into various sub-branches, one of which is kink, where all of this area is really about transgressing what are considered the boundaries of acceptable sexual conduct. Now, the boundaries of what is considered acceptable sexual conduct can be of one or two natures. It can be social norms, or it can be the criminal law that tells you can't have a sexual relationship of that kind. So that's just generally what the queer studies is about, including the branch of queer studies that talks about minor attraction. And of course, one thing that you will really, really struggle to find, in fact, I would suggest you won't find it at all, is any significant representative of the branch of queer studies who categorically says that paedophilia is wrong, because it is so much about anything that is transgressive. It is what queer studies is all about, essentially.
Queering society.
Well, exactly. I also come back to the question that I asked for a definition of the Q+ in LGBTQ+, because I don't know what the Q+ is. I know what LGB is. LGB is about two consenting adults of the same sex loving each other. I know what the T is. The T is a male identifying as a woman or a female identifying as a man. So I know what the LGBT is in LGBTQ+. I don't know what the Q+ is, but it must be things that isn't covered, things that aren't covered in LGBT and not covered in the T. So what is left? If I want to cover sexual diversities that don't just involve the heteronormative and also don't involve the LGBT, what other form of sexual diversity is left to fall under the Q+, if not the things that are currently considered sexual offences? Because anything that is sexual intercourse between two consenting adults is already covered under the LGB. What's left for the additional sexual diversity to fall under the Q+? That's just a question to which I wanted an answer from my manager in a situation where we had a task that involved a sexual relationship between an adult and a minor, and it is something to which I never got an answer.
It's a dangerous question, I suppose that's why.
Yes.
I've got a question here from Catherine, and she's asking, do you think that students who've been sold this ideology as fact might in future have recourse against the Open University for selling them a degree that's not fit for purpose?
That's a very interesting question. To be honest, I mean, as a lawyer, I'd say probably not, in the sense a sense that it is for the university to set its curriculum, and it would be very difficult to say that the university went beyond what it can legitimately do in setting its curriculum in a way that replaces actual teaching with just ideological indoctrination, especially in a situation where this is a regulated institution that is still licensed to give people degree courses, and also in a situation where what the Open University is doing isn't wildly different from what's going on in a lot of other universities around the country. So in that sense, I think quite possibly not. Now, again, I come back to the fact that my family has lived through 2 totalitarian dictatorships, and in both dictatorships, you ended up with a university degree after going through a period of indoctrination as much as higher education. And by and large, people weren't wildly unhappy, quite frankly, with the degrees that they got from it. I know there are Open University students who are very unhappy about the fact that their degree has turned into anything from indoctrination to a Chinese struggle section. But they are, I think, a minority. And that is not specific to this ideology. In my experience, the typical Open University students these days wants a degree, and they're not that fussed what the content is that gets you that degree ultimately. Almost their priority is often being able to get the degree, being able to get the good mark in the degree, and being able to get that for not too much effort. Well, in my experience, those are the priorities of students. So in that sense, I don't expect that many students complaining, particularly if you actually make clear it's not that hard to get a good mark in this course, so long as you regurgitate that ideological indoctrination that we've given you, so long as you confirm that the LGBTQ plus community are the most oppressed of them all, you get a great mark. What's not to like from the perspective of most students? So that's one thing. The other thing is that I think students, undergraduates in particular, are perhaps not in that good a position to actually assess to what extent they're getting a decent higher education or not. Because, well, these are people who've only just come out of school often. Well, with Open University students, they might have been around the block in other ways a bit more. But this is their first experience of university. This is the only experience of university they'll ever have. Are they really in a position to challenge what is being handed to them as a university education and say, this is not the degree I wanted. This is not what I signed up for. Some do. I know some do. I get contacted by students who've been having those kinds of conversations with their faculty. But in my experience, most students actually don't.
They just want to get the degree and be off and get a job with it.
Understandably, sometimes it's a case of almost, I don't care so long as I get that degree. And sometimes it's just, well, that's what seems normal to them. That's the only form of university they know. Why would they question it almost?
But of course, that is a consumerist outlook, isn't it? I mean, you're talking about academic freedom of expression and the need for academics to refine their thinking through being challenged by their peers, like peer review of your publications. That's how things get better, is that you put something up, somebody else attacks it, and then you go, oh yeah, well, maybe. So if the student is allowed to carry on without check, without having to challenge what they're being told, how valuable is the process? From my point of view, studying was a point of reading through all the works and looking at the various different points of view and saying, well, that doesn't make sense if you compare it with that.
Yeah, I mean, you mentioned the consumerist outlook, and I think that's almost a topic for a whole separate session.
Yeah.
The extent to which students have become the customers of the university these days, and the customer's always right, and we will do whatever keeps the customer happy rather than anything else. And as I said, I'm not convinced that most students demand to be intellectually challenged if you offer them an alternative of just getting the degree that they want for something else. Yes, of course. I think a higher education should offer the student the opportunity to learn how to think, not what to think, the opportunity to develop their critical thinking skills. And whatever subject they're studying, you should introduce the student to the full range of ideas that are out there on the topic, and then equip them with the skills to grapple with all those different ideas and make up their own minds on those different ideas to which they've been introduced, and learn to articulate their own views on this, rather than being told, okay, out of all these ideas here, that section is completely banned to the point that you can't even mention it in the classroom. This is the correct one. But I mean, that is what's going on in universities today. And you
Not
get
just the Open University.
Yeah, I'm not sure it's the majority of students.
Yeah. Okay. Right. Now, here's a question that I don't know whether you can even entertain, because it's not your topic. You're a lawyer, but supposing this liberating the curriculum notion is applied to, let's say, technology, engineering, science, and various other aspects like that, where there are hard facts at play, and actually people's lives can be ruined or lost because the tolerances of 0.5 microgram isn't observed.
Yes, I mean, it certainly happens in those kinds of faculties as well. There are academics from those kinds of subject backgrounds who can talk a lot more eloquently, actually, probably, about the kinds of absurdities this creates. Of course, you get these arguments that things like math itself is in some way white, and that math itself is in some way colonial. Yeah, it is. In the examples you give, you can see just how absurd that idea is, because no matter where you are in the world, the numbers add up in exactly the same way, and a bridge will hold up under the exact same circumstances. But if you look at who goes into what discipline, perhaps you can already see some of the impacts that this is happening. And of course, interestingly, if you look you compare, for instance, students from the global south or from developing countries who come to the UK to study, engineering is quite a popular subject for them to study, because those are really useful skills that they can take home to their countries. And so if you want to really decolonize through your education, you might want to equip as many people as possible from countries that haven't got enough infrastructure to know how to build the infrastructure. Whereas if you get this sort of American homegrown sort of anti-racist, they will teach you that no person of color should ever waste their time learning maths or engineering, when they need to learn about the oppression of Black people first of all, because what this should all be about is developing critical consciousness and awareness of the oppression that people are suffering.
I see. So then the students there, their capacity to learn real engineering and the formulae that they'll need in their future lives is diminished, because they have to give time to critical race theory or some other queering society thing.
Well, I would say it probably does have that kind of impact, doesn't it? And it also almost encourages people to give up on the hard and boring stuff. If I think back to my math lessons in school, I don't know about you, but I found it incredibly boring. My math teacher then just used to tell me to get on with it, because you needed to know that sort of stuff. Whereas, of course, students these days have all manner of arguments of saying that they belong to oppressed groups that really shouldn't be expected to have to learn maths in the same way. Now, whether you are doing these students a favour or a disfavour in the disguise of EDI is a different matter. I think it's the latter.
Yeah, I agree with you, because maths is an international subject, isn't it? I mean, our whole notion of number and the way we express our numbers, it used to be Roman numerals. Now it's Indian and Arabic numerals as transmitted. In India, they have crore and lakhs of numbers of rupees, different order of magnitude from what we're used to, but they make it work. So that's a sort of international point of view. It's really interesting to feel that the customers, and a lot of our universities' customers come from places like China, where they were yearning for Western education. Are they going back and saying that isn't what they got?
Well, that's an interesting one. Are they going back to China and saying they haven't got what they wanted? I haven't heard of it happening, and being very, very stereotypical. You don't often get Chinese people complaining about anything. You don't often get Chinese students complaining about anything. I think on the whole, they do still get the engineering, the degree that they came here for as well. It is just interesting, the idea that people from the global south, people from the former colonies, often think that actually the way for them to achieve equality in the global economy will be to learn these STEM subjects, these hard sciences, whereas the decolonizers that invariably seem to come from the Anglosphere in North America tell them that to achieve equality, they need to learn critical race theory and understand their oppression.
Yes. Okay. Now I've got a question. Jane, you wrote this in the chat. I don't know whether you want to ask it about employers. Do you want to ask it, or do you want me to? Is Jane with us still? I think I better ask it for you. Post qualifying, Almut, has there been feedback from employers, maybe to you or to colleagues that you know who are in the different research networks? Has there been feedback from employers about the quality of their recruits who've been taught in this decolonized curriculum way?
Anecdotally, you hear it or not. I don't know whether it's happening on any formal level. I'm not aware of it happening on any formal level. But yes, I think you do hear employers generally complaining about the caliber of people that come out of universities these days, who sometimes lack the basic skills for which employers used to hire graduates. And that perhaps has a lot to do with the fact that universities set out to train activists rather than train people in the various academic disciplines that are offered as degrees by a university.
Yeah. Now, I know from a number of different specialisms, there's surveyors, there's lawyers, architects, and similar backgrounds. They're recruiting apprentices rather than recruit from university graduates in their discipline. They're recruiting school leavers to come and take an apprenticeship, and they'll be able to go through the process of learning on the job, as well as a day release learning the facts of the course curriculum at a local university. Now, they're coming out, those youngsters are coming out of the process with the qualification, the experience, and no debt. Why would you want to go to a university away, get into £50,000 worth of debt, not necessarily get the experience? Well, you wouldn't get the experience because you've been in the university, and find that you've been taught stuff like critical race theory or liberated curriculum stuff or Freirean conscientization, let's say, which was, that was one of the things I was finding out about when I was in work. Aren't the universities making a rod for their own backs, is what I'm asking.
Well, that's the $1 million question, isn't it? You may well ask, if you're not going to get the intellectual life that universities have traditionally offered you, is it worth going to university? And of course, the interesting thing is that I think Gen Z, from what I've read quite recently, are actually less likely to want to go to universities than school leavers in previous years.
Yeah.
Now, there might be many reasons for it, and different explanations have been offered for it. But even 10 years ago or 5 years ago, I think people still assumed that the number of school leavers who go on to go to university will keep going up and up and up, or up, and it will only ever go in one direction. We now find that Gen Z actually doesn't necessarily want to go to university. You can offer different reasons for it, but you might want to consider whether the fact that they're actually offered that kind of indoctrination with fairly vacuous theories instead of a proper university degree could be one of the reasons why it's not as attractive anymore going to university.
Yeah, good point. Good point. Now, you did talk to us about the OU's response to the Phoenix case, and they didn't support their professor against bullying and harassment. They don't seem to have learnt. And yet, I understand there's been a review by Professor Dame Nicola Dandridge about what they did, what they went through, and what next for universities. How's that review been seen?
I mean, the Dandridge review was a farce from start to finish, wasn't it? I don't know anyone other than perhaps a handful of university top leaders who's had a good word to say about the Dandridge review. I challenge anybody on this call to show me one voice who said this was a good thing. I mean, I could spend a whole evening talking about what was ridiculous about the Dandridge review. Well, I've talked about the fact that I'm bringing a case about the right to academic freedom and academic freedom of expression as a matter of human rights law. Of course, that's one thing that Dandridge, for instance, hasn't considered. So part of Dandridge's terms of reference would have been to consider the Open University's approach to academic freedom. She hasn't mentioned that the Open University faces an upcoming case in which its approach to academic freedom is challenged. Now, I would add to that, as part of my case, I'm pleading a belief in academic freedom. I'm saying that I hold a belief in academic freedom as a philosophical belief protected under the Equality Act. And I've been discriminated against for holding that belief. The Open University, in response to that, says, amongst other things, that a belief in academic freedom isn't worthy of respect in a democratic society, meaning, as defined in case law, it is no better necessarily than being a Nazi or a totalitarian. They're also not accepting effectively that believing in academic freedom is important, or that it relates to an important aspect of human life. So those are just some bits in relation to academic freedom that Dandridge chose to ignore. She talks about the law at some point. She doesn't talk about the law in relation to academic freedom generally. Now, she wouldn't talk about any of what we've talked about this evening, because she says quite early in her report, actually, that she has decided not to look at the curriculum, not to look at teaching. The way she explains it is that she's been asked to look at academic freedom as it affects staff, and she says curriculum is something that affects students, so I'm not going to look at it. If you look at any definition of academic freedom, it will define it as including freedom in teaching, freedom in learning, and freedom in research. She's just eliminated all the teaching and learning. This is the Open University. It is the largest university in the UK by student numbers. It has more students than any other university in the UK. It is also not what you would call a research-intensive university. So to talk about academic freedom at the Open University without looking at teaching, as Dandridge has done, is, again, absolutely ridiculous as far as I'm concerned. She doesn't really consider what the law on academic freedom is, as I've already said generally. Of course, it also says in UK education law, essentially, that it is the role of universities to ensure that its members can express ideas to the extent that the law allows. Now, Dandridge's terms of reference were to balance academic freedom with EDI. In other words, she's not talking about the right that people have in law. to express at a university any ideas that the law allows. She only talks about academic freedom as far as the law allows and EDI allows. So she's narrowed it down to that point without considering in what ways that is problematic. I mean, I could talk.
But EDI does not have any basis in the law.
EDI does absolutely no basis in the law, even though I think at some point she actually talks about EDI legislation, that kind of thing. She talks about EDI as though it was law. She in no way recognizes that EDI has actually been the force that has curtailed academic freedom at the Open University and at other universities for so long. So her message in relation to the work of the EDI department is essentially carry on and double down. She actually, one of her recommendations is that the EDI department continue their important work of creating a glossary. And in that context, she particularly talks about the importance of them defining words like man and woman. If we think about the kind of issues we've been talking about this evening, where, of course, just about the core question among all the problems around gender critical beliefs in academia come down to the question that people aren't allowed to answer the question, what is a woman, in the way that they think would be the right working definition for them. Now, Dandridge thinks that the EDI department should define man and woman and all sorts of other terms for academics. Now, just why the party or anybody from outside my subject discipline should define my terms for me in a university, I don't understand. You would, if your terms of reference are to talk about academic freedom, you think it's a problem, or at least mention that. Dandridge doesn't. She just suggests a solution would be that the EDI department defines what a woman is for all the academics at the Open University. I could go on. I could talk all evening about the farce that the Dandridge review is, but I think the bottom line is that, for very good reason, nobody has really welcomed it. Nobody has had a good word to say about it. And it's also interesting, of course, if you think back to my case, what is the Open University going to do if they lose Gadow versus Open University? If they lose a major upcoming case about academic freedom, and they say they've just had their review on academic freedom, and they say they've now cracked the problem of academic freedom with a report that didn't consider my case, are they going to have another Dandridge review into, like, Dandridge 2, the second review of academic freedom? Or are they going to say, oh, we've already dealt with the learnings from Gadow versus Open University in a report that didn't consider any of the issues raised by Gadow versus Open University? It's a farce from start to finish, the Dandridge review.
It's a farce, isn't it? And I noticed at the end of it was the Times Higher Education report, so not the actual report itself. But looking at this, the Vice-Chancellor, Tim Blackman, he says, the Dandridge Review gives us valuable learning and insights into how we can and must change. As a university, we must ensure that academic freedom and freedom of speech are protected more proactively, and that unacceptable behaviours, presumably the bullying and harassment, are challenged and corrected wherever and whenever they occur. Now, that doesn't seem to me to stand straight in terms of what you're saying about them saying that EDI it has more importance.
Okay, I'm just going to ask what tangibly or verifiably will change if they do any of what Tim Blackman has talked about there, or any of the recommendations that Dandridge has made. Well, clearly not. I mean, Tim Blackman is an expert in spouting that kind of hot air, that kind of very vague language. Well, who could disagree with any of what he says? Of course, as a university has to make sure that people have a certain amount of academic freedom and freedom of expression. Of course, the university has to make sure that unacceptable behavior is addressed. What does that mean? I don't see any recognition there of what has been going wrong. I don't see any recognition there of what needs to go different, needs to happen differently.
Yes. Yeah, it's a beggar's belief, doesn't it? It's a very, very smooth managerial speak response, isn't it?
Well, it's another exercise of kicking it into the long grass, isn't it? I mean, they got the Phoenix judgment, then they kicked it into the long grass for a few months with the Dandridge review. Now Dandridge has come back with recommendations that are, broadly speaking, to set up a series of talk shops where people sit around and talk about a few of the issues that she had been asked to review and make recommendations on. Her recommendation is then that other people review the issue and come up periodically with what they think about. Is it going to address any of the problems that led to the issues documented in Phoenix versus University? No, it will not. Joe Phoenix has said as much. Anybody who has any kind of commitment to academic freedom has said it. Like I say, I haven't heard anybody from the Open University actually welcome it. Is it going to address any of the issues raised in my case? No, I think it absolutely won't. They've spent a lot of money on pretending to be doing something when
it's fascinating just hearing your summing up and of some of the issues and some of the genuine conflicts that are likely to arise. It's going to be fascinating. Where exactly do you know where the court hearing will be?
It's probably going to be in Cambridge. So the hearing's been scheduled for 4 weeks at University House for a 4-week hearing in what some people might think is a desperate attempt to drive up costs. I can't remember, it starts on the last Monday in February and then runs for almost the entirety of March, 4 weeks, and it's probably going to be in Cambridge. So the case has been lodged with Watford Employment Tribunal, who are the local tribunal for the Open University based in Milton Keynes. And if I recall correctly, Watford then has sites in Reading and Cambridge and Norwich and somewhere else.
Joe's case was at Watford.
Joe's case was at Watford, yes. I mean, in my crowdfunder, I say that Aqua Roundoff has agreed to represent me. I believe Aqua sits as an employment judge at Watford and at Reading. So if Aqua is representing me, Watford and Reading are kind of out, so that leaves Cambridge and Norwich, assuming Aqua is going to represent me. Yeah. And hopefully it's going to be in Cambridge for those 4 weeks.
Okay.
And hopefully it will also be live tweeted on Tribunal Tweets. We've certainly asked for permission for it to be live tweeted. The Open University hasn't objected, so fingers crossed.
Oh, I think it's going to be a really fruitful occasion. I wish you every good wish, and the idea that a university isn't bothered about academic freedom just blows my mind. One of our comments here is pretty stark. A university does not think academic freedom is worthy of respect or even important. It's just egregious, isn't it? It's just amazing. But Almut, you've spoken to us really, really passionately tonight. It's been a really interesting occasion. We've learned such a lot from you and about the importance of academic freedom. As you say, it's got the highest level of protection. I sincerely hope you win this case. We'll all be helping to propel you onwards, I'm sure. Anybody who hasn't yet seen the crowdfunder and would like to take part in the crowdfunder, I think it may well be here. We'll certainly post it on our summing up after the event. It was right at the beginning. Just a moment.
By all means, if people wanted to share it, I really certainly wouldn't object if you wanted to share it on social media.
I think we will, but it's definitely on your own your own Twitter handle, which is at Almut Gadow. It's there on your own homepage, and we can certainly see it whenever we want to. And no doubt you'll be getting more sign-ups to that after this event tonight. So thank you very much for coming along and talking to us about this. Thanks to Rachel as well for managing the event for Liberal Voice for Women. Hopefully we'll be able to put the talk up on our YouTube channel as soon as possible. Thank you everybody for your great questions and your comments in the chat. It's been really, really interesting. And